Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Welcome to Synergy's Third Thursday webinar. My name is Jason Lazarus, and I'm the Chief Executive Officer of Synergy Settlement Services. And I'll be presenting about ethical issues and malpractice concerns at settlement and closing cases compliantly. So there's a lot to cover today. The roadmap is pretty simple. We're going to first start out talking about disability planning and people that are on needs-based benefits such as Medicaid and SSI, then transition to Medicare. I'm going to touch on the Affordable Care Act a bit and settlement trusts, and then dive into the ethical and malpractice issues that can arise at settlement, and finish up with a brief discussion about qualified settlement funds. So getting right into it, disability planning and public benefits. This area is a fertile ground for confusion and frequently trips up trial lawyers. So I wanted to start off with a brief summary of the different types of public benefits, because frequently clients don't know the differences between the different types of public benefits they're receiving and will confuse them. And you really have to decipher exactly what the clients are on in order to know what needs to be done. So if clients are on either SSI or Medicaid, those are needs-based benefits, and typically speaking, even a small amount of money could render that client ineligible for those benefits. So you have to be very careful when settling cases for clients who are receiving needs-based income and asset-sensitive benefits. Entitlements are a little bit different, and that's SSDI and Medicare. So if a client is disabled and on SSDI, then they're going to be a Medicare beneficiary at some point during your representation if they're not already. So that's where you have to be concerned about the Medicare Secondary Payer Act and Medicare Secondary Payer Compliance, and we'll get into all of that in just a few moments. But there is a connection between the needs-based benefits, SSI and Medicaid. So if you get SSI, then in most states you're going to automatically get Medicaid. And so you have to remember that if you have a client who is on SSI, then they're most likely going to be a Medicaid beneficiary. Same thing with SSDI. SSDI is the way that you get access to the Medicare system prior to retirement age. So if a client has become disabled, has paid in the system, and is getting SSDI, then they are going to be a Medicare beneficiary, which implicates the Medicare Secondary Payer Act. So the question is, why do you have to do planning for clients who are disabled? And the primary reason is because in most instances, there is a need to preserve those public benefits because of the lifetime financial support and medical care that they provide to those that are disabled. And frequently cases are settled for less than full value. And so the clients really do need to rely upon public benefits to fill in the gaps where the settlement dollars don't cover what they're going to need in the future. The other reason is that the type of planning that's done for people that are disabled does create a system of advocacy for someone that's disabled, because typically they're going to have a trust with a knowledgeable trustee who can help manage their financial affairs and make sure they stay eligible for their government assistance. So it is really exceedingly important for most clients to have this type of planning done if they are disabled and catastrophically injured. But not every disabled client is going to need this type of planning. It's only those that are severely disabled that they meet that definition of disability for public benefit programs. And if they are disabled and receiving benefits such as SSI and Medicaid, or they're on Medicare, or they're dual eligible, that's where we have to start looking at some different planning techniques and devices to keep them eligible for those government assistance programs, which is what I'm going to talk about in more in depth here in a moment. So I wanted to go over some of the basics first about the needs-based benefits, which are Medicaid and SSI. So SSI and Medicaid benefits are both income and asset sensitive. The SSI program is a cash assistance program for those 65 or older, blind, or disabled. And it is for people who have not paid into the system enough to get qualified for Social Security disability, SSDI. So SSI is a disability payment, just like SSDI, but SSI is needs-based, and it's for those who have not paid into the system. So if someone qualifies for SSI, the maximum monthly benefit is $771 for 2019 if they're single, and $1157 per month if they're married. So it's a small amount of money, but it's very important because it's the gateway or key to Medicaid. And the income cap and asset cap for these programs are very low. The asset cap is $2,000 in total assets for someone that's single, or $3,000 if you're married. So very, very, very low. So Medicaid is connected to SSI in that, as I said, if you get $1 of SSI, in most states you automatically get Medicaid, which is basic health care program for those that are indigent. So if a client is disabled on Medicaid and SSI, that's when you should consider a planning device such as a special needs trust. It's not the only one, but it's the primary one, and we'll talk a little bit more about the solutions in depth. And the reason why you need to consider it is because if settlement monies are received by that personal injury victim, then they are going to lose their eligibility for SSI and Medicaid. In the month they get it, it's income. The next month, if it's not spent down below the cap of $2,000, if they're single, or $3,000, or if they're married, then it's accountable resource. So it's income and a resource. And for most clients, oftentimes they will tell you that they are not upset about losing their SSI because it's such a small amount of income that they get from that program. But the problem is that they don't realize when they lose the SSI, in turn, they're also going to lose their Medicaid eligibility because that's the way they're qualifying for Medicaid. So moving on now to what you do for clients that are receiving these needs-based benefits. Well, they need some type of planning and advice. They simply cannot be left with the settlement proceeds and no planning whatsoever, because they will become ineligible, and that is a situation that you don't want to find yourself in with a particular client if they're getting these benefits. So to have a better understanding of what the solutions are, I wanted to explain about special needs trust, because in most instances, that is going to be the planning device that you use to keep that client eligible. There are three primary different types of special needs trusts that can be utilized in a personal injury settlement. The first is what I call a D4A, or standalone special needs trust, that can be created for anyone that's disabled and under the age of 65. The next is a D4C pooled special needs trust, which is the same as a standalone special needs trust, except that you have a not-for-profit trustee and there is no age restriction, so it can be created for someone that's disabled and over the age of 65. The last one is a third-party special needs trust, which typically arises in the context of family members who have assets for the loved one that's disabled, or it also can arise in situations where the community does a fundraiser for an injury victim, or even possibly a GoFundMe. So there's a lot of different instances where third parties will come up in personal injury context, but typically speaking, if it is a settlement that the client needs to plan for, then we would be using either a D4A standalone or a D4C pool trust. So the advantages of these trusts are that they keep Medicaid and SSI eligibility intact regardless of how much money is in that special needs trust. You could have $10 million and still get Medicaid and SSI as long as it is properly placed into a qualifying special needs trust. These trusts have professional trustees, and typically speaking, that can avoid guardianship and annual reporting requirements for someone that is considered incompetent, legally speaking, or for minors. And then these types of trusts can pay for nearly anything. The real primary exception is food and shelter, and that's for those that are SSI recipients. If the trust pays for food or shelter, it automatically reduces the trust beneficiary's SSI benefits. So typically speaking, those distributions are not made. So what are the disadvantages of setting up a special needs trust? Well, there is an unrestricted use of the funds, so the client has restrictions on how they can use the money. It can only be used for the client's sole benefit. Obviously, I already talked about the food and shelter restriction. At death, Medicaid has to be paid back from what is left over in a special needs trust. It is part of the federal law that any special needs trust, to qualify and be exempt from accountable resource, it has to have that payback provision. And then these trusts do add an extra layer of complexity to a personal injury settlement, and they're irrevocable. So once the trust is established, it can't be undone. Now, in certain instances, a special needs trust might not make sense because you might have a client who wants to buy, say, a house or a car, and that would use up most of their monies. So that falls under exempt assets. So exempt assets, the primary ones are a house and a car. There's some small other ones, but your house and everything contained in it, so appliances, fixtures, furniture, all those things are all exempt. So sometimes clients will prefer to spend all of the money down to get below that asset cap, the $2,000 or $3,000, depending on whether they're single or married, as an alternative to setting up a special needs trust. And that's perfectly fine. The client just needs to understand that they have to spend it down within the same calendar month they get the money, and it can only be used for exempt assets. They can't have that money in any type of investment or bank account. That's considered available, but they can spend it on exempt assets. So that's exempt assets. The other thing to be aware of is deeming. And this is one of those issues that creates some difficulties when planning is done at the end of a personal injury case, because what really causes a problem are consortium claims. So, for example, you've got mom and dad who's got a consortium claim for, say, a hypoxic brain injury for their minor child. The minor child, the case settles, and a special needs trust is established for the minor child. All the child's money goes into that, or possibly it's funded with a structured settlement over time. And great, you think that everything's covered. But mom and dad also have a consortium claim, and you give them a couple $100,000 for their consortium claim, even though the child got $3 million and it's in a special needs trust. The $200,000 you gave mom and dad for their consortium claim is deemed to the minor child. So you have just disqualified that minor child even after doing all the planning. So you've got to be careful about the construction of the settlement, because if deeming occurs, all the planning you've done for that person could be destroyed by the deeming. And it's between parent and minor child and a husband and wife. So the same issues arise with a married couple. So be aware and be cognizant of that when planning is done. I wanted to talk briefly about pooled special needs trusts, because we see their use more and more these days because they're easier to create, they're cheaper, and they operate identically to other special needs trusts, but without the requirement of putting $500,000 or $1 million into a trust, which is what most corporate and bank trustees want if they're going to manage a special needs trust. So these types of trusts are created pursuant to federal law. They have to be established by a not-for-profit that acts as trustee. Each client has their own separate sub-accounts, but the funds can be pooled from an investment perspective. But the person who is joining the trust has to be disabled, which is a requirement of any special needs trust. And then at death, that Medicaid payback I talked about applies. So pooled special needs trusts are different from standalones in that the injury victim creates it for themselves. There's no age restriction, as I said before, and the trust beneficiary is establishing an already established master trust. So there's no need to draft an individually tailored special needs trust. And the advantage is typically the fees are going to be lower and there's no minimum trust size. So frequently they're a great solution for personal injury settlements. They're typically friendly to being funded over time by structured settlements, which actually makes it more tax efficient as well as lowers the operational fees of the trust by having a smaller corpus in the special needs trust. So I wanted to go over a couple of FAQs because it's important to understand this. As a starting point, a client must be disabled within the Social Security definition of disability to create a special needs trust. So they've got to be disabled in order to qualify. Some Medicaid programs are family-based and people are not disabled. And so in that instance, they can't join the pooled trust because they don't meet that definition of disability. And when somebody wants to join a pooled special needs trust, all they have to do is complete what's called a joinder and provide the required information. So it's pretty easy, pretty direct, and very quick to establish one of these types of trusts because you don't have drafting time and creation of a standalone special needs trust document. And as I said, there's no minimum, so you could have even a $10,000 settlement put into a pooled special needs trust. Oftentimes, the analysis should be is whether it does make sense in that scenario. In a scenario where you've got a relatively small amount of money, it may not make sense to establish a special needs trust. Instead, a spend down, which I talked about previously, is what might make more sense. So when a pooled special needs trust is established, you can add funds to it. So say the case has multiple defendants, you could establish a pooled special needs trust. When the case resolves with one defendant, it would stay open and could be funded further by the next personal injury settlement that's part of the overall global resolution of the case. And for clients that are using a special needs trust like this, when they need money, they make a distribution request. So it's quite easy to use the money for most clients. Many pooled trusts will have ways for clients to utilize the monies in the trust rapidly by using something called a TrueLink card, which is a Visa credit card that can be loaded each month for trust beneficiaries to make it easier for them to spend the money that's in the pooled trust. These trusts do generate some taxable income, but for most clients, that's really negligible and the trust can pay for any tax burden. The one thing to understand is how the monies can be used. So as I said before, there's a requirement that the monies be used for the sole benefit of the trust beneficiary, and the trustee can never give the trust beneficiary cash. Instead, it pays for supplemental needs, but the supplemental needs can be for a variety of different things. Anything that improves that client's quality of life are things that it could pay for. Rehabilitative and occupational therapy, supplemental dietary needs, travel, companionship, cultural experience, vacations, entertainment, supplemental nursing care, medical procedures, private case managers, training and education programs, expenses associated with having family members provide caregiving services. So it is pretty much anything that can help that trust beneficiary out. So before I transition away from the needs-based benefits, one more recent tool that's being utilized is ABLE accounts. And ABLE accounts are sort of like 529 accounts, but can be created for those that are disabled prior to age 26. So you have to have someone that became disabled prior to age 26 for them to be able to establish an ABLE account. With ABLE accounts, you can put in up to $15,000 yearly and no more than $100,000 total going into it for it to keep them keep it as a non-countable resource. The nice part about ABLE accounts is it doesn't have the food and shelter restriction like Special Needs Trust does, so it can be used pretty much on anything. Even, for example, say medical marijuana, that's something that typically is difficult for a Special Needs Trust to pay for, but that is something an ABLE account could pay for. These accounts do have the Medicaid payback requirement like Special Needs Trust, but other trusts, so say you establish a pooled Special Needs Trust, that can be used to fund an ABLE account, which is helpful because the Special Needs Trust can pay for the things that it can pay for, while the ABLE account can be used for things that typically you can't use a Special Needs Trust to pay for, and gives that client some added flexibility. And oftentimes structured settlements are used to fund Special Needs Trust and the ABLE account, so it's a pretty tax efficient way to manage the recovery. All right, so quickly covered Medicaid and SSI. Just remember those are the ones that are needs-based, and if your client's getting those and you're giving them more than $2,000 if they're single, or $3,000 if they're married, you could cause an eligibility problem for that client. So Medicare is different. Medicare is not income or asset sensitive. It's called an entitlement. It's funded by the taxes we all pay into the system, and if a client has enough quarters paid into the system, becomes disabled, then they can get Social Security disability. And then Medicare entitlement is 30 months after disability, and that 30 months comes from 6-month elimination period, and then 24 months thereafter, they become entitled to Medicare benefits. And Medicare coverage is made up of Parts A and Part B, which covers your hospital insurance and medical insurance, and Part D, which is prescription drugs. Part C privatizes Parts A, B, and C into a plan that's run by private insurance companies, approved by Medicare, but using Medicare dollars. So Part C plans, or Medicare Advantage plans, are plans where the client have elected out of traditional Medicare Part A and Part B. And this is important, and you'll get an understanding of why when I talk about conditional payments and Medicare Advantage plan liens. But just remember that clients can elect into an Advantage plan, and you really need to know if they have a Medicare Advantage plan, particularly when it comes to the lien resolution aspect of Medicare. So if you have a client who is on Medicare, that implicates the Medicare Secondary Payer Act, the MSP for short, which precludes Medicare from making payments for service to the extent that payment can reasonably be expected to be made by workers' comp, liability, or no fault. So Medicare is always supposed to be a secondary payer. And according to CMS, which is the agency charged with interpreting the Medicare Secondary Payer Act, there are 2 obligations that arise at settlement with a Medicare beneficiary. One is to resolve any payments that were made prior to the date of settlement, that's conditional payments, and then deal with the Medicare futures issue, which is the Medicare Set-Asides question. And I'll dive into that in a moment. First, I wanted to just spend a brief amount of time talking about Medicare conditional payments and MAO liens. This area has become a very fertile ground for government action against law firms. There have been 2 cases in the last year where the Department of Treasury has, and the DOJ has gone after plaintiff personal injury law firms for failing to repay Medicare. So make sure that you have a process and plan in place within your firm to deal with Medicare compliance. when it comes to resolving Medicare conditional payments, there's really only a couple of different options. And the recent settlement that the DOJ announced with a law firm had to do with their failure to go through the proper process and relying upon information that was not final. If you do that, you're exposing yourself, and that's exactly what happened with this particular law firm where the DOJ went after them. So keep in mind that you've only got a couple different options here. One is when Medicare issues the final demand, you must pay that amount because if you do not pay it, it will get referred to Treasury, and then ultimately DOJ is going to be knocking on your door. So you pay that amount after you've done audit and verification. The alternative to that is appealing what Medicare says is due via the final demand. Just know that that is a lengthy process, and interest will continue to accrue on top of the Medicare final demand amount if the final demand amount is not paid. What we recommend to most clients is pay the final demand and then pursue compromise or waiver under different provisions in the law that allow for this. So there are three different ways to go about it. The first is a financial hardship waiver under Section 1870C. This is done through BCRC. And basically, if a client has a financial hardship that justifies a full or partial waiver, then Medicare will consider that. And there's a form that has to be filled out. But basically, if a client is on, say, Medicare and Medicaid, they're dual eligible, so they're on a needs-based benefit, usually that will qualify for a financial hardship waiver, even if the case resolved for 7 figures. Had a case where that was exactly the case, was a 7-figure settlement, elderly woman who was shot multiple times. It was a negligent security case. We pursued a waiver, and Medicare refunded the entire amount that was paid for her conditional payment final demand, even though she had a 7-figure settlement because she was on Medicare and Medicaid. The other ways to do it is compromise and best interest of the program waiver. These are pretty broad and encompassing, and that's where you can make arguments about whether Medicare should be pursuing recovery in this particular instance because of the equity and fairness in that particular instance. And most lawyers and law firms don't even know about this process. But the best part of it is that if you pay the final demand, it stops the interest meter from running. And then, believe it or not, Medicare will cut a check back to the client for the full amount of the lien if they waive it completely. And many lien resolution companies out there say this is impossible, but the numbers don't lie. So last year, our lien resolution group was successful 76% of the time in getting money back from Medicare. Last year, we recovered $1.1 million on behalf of Medicare beneficiaries, and the average amount Medicare beneficiaries got back was over $20,000. And since we started this service, it's recovered in excess of $5.3 million. So it's very much a reality, and we're very successful at getting this. If you are not doing this for your clients, I would highly suggest that you retain us to do it or learn the process to doing it, because this is a very successful way to make sure your clients are protected. So I wanted to talk about Medicare Advantage Plan liens, Part C, or hidden liens as I call them. The reason I say they're hidden is because when you call up Medicare, if a client has opted into a Medicare Part C Advantage plan, Medicare does not have any information. So if you call Medicare up and they say there is no final demand amount, that likely means, if you know the client's been treating, that they had an Advantage plan. The reason is because if Medicare says they've not paid anything, medical bills were paid and they have no information on it, that means that there is an Advantage plan out there. And the problem is that there is a private cause of action for double damages if a Medicare Advantage plan is not reimbursed. And the Medicare Advantage plans have had this private cause of action, which was really established for Medicare, extended to them by 42 CFR 411.108. So that means that these Advantage plans can use that provision to go after not only insurance companies, but lawyers. In the Humana versus Western Heritage case, which comes out of the jurisdiction we're based out of in the 11th Circuit, the court held that Humana was entitled to double the amount of the lien from Western Heritage, the liability insurer in that case. So obviously that is very troubling for attorneys that are out there practicing in representing Medicare beneficiaries, because sometimes they're just not aware that these liens are out there. But you need to be understanding of the kind of liability that you face. So I wanted to just go over this briefly because I think that it's an area we're going to continue to see these Medicare Advantage plans pursue aggressively the double damages provision under 42 U.S.C. 1395Y, which is up on the screen. But the problem for lawyers, trial lawyers, is that 42 CFR 411.24 allows Medicare, and by extension Medicare Advantage plans, to go after an attorney for this type of recovery. And there's certainly case law out there where Medicare has pursued attorneys personally for failing to reimburse Medicare. There's a case out there that we were actually involved with a law firm that we do work with, where they were sued by Humana for double the amount of a lien that they failed to reimburse the plan for. So these Medicare Advantage plans have become very aggressive. Our lien resolution group is pretty successful at resolving Medicare Advantage plan liens with a resolution percentage of almost 60%. These plans can be negotiated with, but you really have to know how to push the buttons and navigate the process. But the biggest thing to take away from this is make sure that you know what benefits your clients are getting, and make sure you know whether they are receiving benefits under an Advantage plan, because if they are, then they're going to have these liens out there, and you want to make sure you identify and resolve those without fail. So that brings me to an issue that troubles trial lawyers. It's Medicare Futures and the MSA Conundrum. So I wanted to give you a little bit of background about why this has become such a hot button issue with both insurers and with trial lawyers. It's because of Section 111 of the MMSEA, which was a law that created mandatory insurer reporting. What mandatory insurer reporting requires is that every settlement of $1,000 or more with Medicare beneficiaries has to be reported to Medicare by the defendant insurer. And this reporting requirement is a data dump. It requires a lot of information be reported to Medicare, which includes the ICD codes related to the injury diagnoses for your client. And the reason that becomes important is because you want to make sure that the correct information is ultimately reported to Medicare, because when Medicare has this information, it is what can trigger a denial of care, which is what implicates the whole Medicare Set-Aside issue under the Medicare Secondary Payer Act. But so as a practice point, you want to make sure that you know what the defendants are reporting, because if they report the wrong injury diagnosis codes, that could pose a problem for your client. So say, for example, there's an auto accident case and there's an allegation of neck and back injuries, but throughout the litigation, the defendant takes the position that the neck is pre-existing, and ultimately the case settles for the value of the back injuries. But when it comes time to report, the defendant reports both the neck and the back codes. That could cause the client a denial of care for the neck-related treatment as well. And the other problem that can arise is when this reporting is done, if the wrong date of accident is used or a subsequent date of accident is used, that can trigger an additional final demand from Medicare, and it can screw up the Medicare conditional payment resolution process. So you got to be aware of this and make sure you're dealing with it up front. So the reason that all of this creates such an issue for clients after the case settles is because what happens if your client is denied Medicare coverage for injury-related care after the case settles? And the answer is they have to go through a lengthy Medicare appeals process before they ever got inside of a federal district court to argue that it was improper for their care to be denied. All the while, they would have gone without care. And there's a lot of case law out there about the need to exhaust these internal appeals processes before a federal district court will accept jurisdiction. So it's unlikely that the client would ever accelerate this process and get inside of a district court. Instead, they're going to go without care while they go through this appeals process. So it poses quite a risk for the injury victim if they're catastrophically injured, and they lose their Medicare coverage because the defendant reported all the ICE codes and Medicare flagged it and refused to pay. So that's the risk. So what is a Medicare set-aside? Well, all it is a amount of money that's set aside out of the personal injury settlement to pay for Medicare covered expenses. So it's like a deductible, it's a carve out. And the way it's calculated is you take all of the injury-related medical expenses normally covered by Medicare, plus annual prescription costs that are covered by Medicare, multiplied by life expectancy, and that's what a Medicare set-aside allocation is. So that's the amount, that's how it's calculated, the amount to be set aside. One important point is that because life expectancy is part of the calculation, Medicare does consider reduction of life expectancy in the context of figuring out how much should be set aside. So rated ages, which are used in structured settlement pricing, are accepted by Medicare as evidence of a reduced life expectancy. The shorter the life expectancy means the total amount set aside is less because that's the multiplier. And the other thing too is that structured settlements typically represent a very large cost savings to funding a Medicare set-aside. So typically speaking, Medicare set-asides are funded with structured settlements because you are achieving a pretty large cost savings by funding it over time instead of with a single lump sum. And because Medicare specifically approves of this methodology, it is something that typically is used for settlements. So one of the questions is, well, what is the law? What do we have to do to be compliant when it comes to Medicare Secondary Payer Act in 2019? So right off the start, you should understand that right now, there's simply no regulations or statutes or case law requiring a Medicare set-aside. But it's similar to what I started out the conversation about with planning, which is people that are on needs-based benefits, you have to advise them, hey, there's this thing called a special needs trust. If you put your settlement into it, you can keep your eligibility. So Medicare now is really no different. You need to advise clients that, hey, there's this thing called a Medicare set-aside. It can prevent Medicare from denying future injury-related care. Here's how it works, and explain that to the client. One important point, though, is you only have to worry about this issue if you're dealing with a current Medicare beneficiary. So that means they're disabled, 65 or older, have end-stage renal disease, ALS, or a disabled adult child, or someone with a reasonable expectation of becoming a Medicare beneficiary. That means that they've applied for and been accepted for Social Security disability. Those are the only two classes of clients that you have to worry about this Medicare futures issues with. But two, what you should always understand is there is not necessarily a requirement to set anything aside, because there are ways to deal with avoiding a shifting of the burden. So the shifting of the burden to Medicare from personal injury settlement dollars is what is the problem under the Secondary Payer Act. But clients who have elected into a Medicare Advantage plan, for example, they're not shifting the burden to Medicare because there is no, by extension, set-asides to Medicare Advantage plans, at least as we sit here today. But two, they could elect to become privately insured. They could self-pay. They could set up a trust to pay for future medical or a structured settlement. So there are alternatives to doing MSA. But if you have a client who's Medicare eligible, they're going to need to treat for future medical, and there are settlement dollars that are allocated for future medical, that's when you should consider a Medicare set-aside or possibly an alternative to it. Now, Medicare's position is that a set-aside is their preferred method to protect the trust fund, which of course is what they say. One thing to be aware of, though, is that while I've said there's no current regulations, there is a move afoot for this to change. So what you see on the screen is something from OMB, which has got to do with Medicare's attempt to regulate this world of Medicare set-asides. And, you know, it is pretty clear from everything that Medicare has been saying that they are moving forward with creating a regulatory framework for Medicare set-asides for all cases, not just workers' comp, but liability settlements as well. Amazingly, even in workers' comp, where set-asides are done routinely, there's no law. It's all Medicare policy or CMS policy. So the fact that they're moving to a regulatory process makes sense, but it also brings a bit of the unknown. But I do think that by the end of 2019 or early 2020, we should see some regulatory action in this arena. So the question is, how do you become MSP compliant in 2019? And the answer is your firm needs a process and a partner to help them through this. But you've got to start early on and make sure you get the public benefit data for disabled clients. You got to make sure you're in control of that MSP process from start to finish, because I can tell you this, that the defendants are hypersensitive to this, and you're likely going to see pages and pages of Medicare language if you settle that case and you've not discussed the issues when you get the release, because these releases are typically draconian and have provisions in it that are ridiculous. And that's, you know, what you're going to see. So part of this is you got to be proactive about it. You cannot rely upon the other side when it comes to MSP compliance issues, and you don't want to rely upon any of their people for the right solutions. And lastly, you've got to make sure that the correct data is getting reported to Medicare when the defendant reports. So as I said, you know, this is an area where you need a process for your firm. So you've got to identify cases with Medicare clients, and if they are settling their case, determine if future medicals are funded, and if they are, educate that client on the risks of failing to do a set-aside, and then help that client select the appropriate solution for them, which typically is working with a firm like us to go through these different options with the client so they understand it. And the easiest way to remember it is the acronym CAD, consult experts, advise the client about MSP, and then document your file. You got to document your file. So one last point about Medicare set-asides is, what do you do when a case resolves and the client is setting up a Medicare set-aside? So typically, they should have it professionally administered, because most clients really have no ability to manage a Medicare set-aside, because they have to make sure the funds are properly invested, then they have to make sure that the monies are spent properly, and they have to report to Medicare. So one solution is a pooled Medicare set-aside trust, which is a cost-effective solution. It's the same concept as the pooled special needs trust I talked about earlier, but it offers all the bells and whistles for the client to have that set-aside be a no-brainer for them. They don't have to think about it. They get a card that they present when they go for medical treatment, and the trust pays for the Medicare covered services as long as it's part of the MSA. So for most clients, it's going to be the right way to protect them. So I wanted to talk real briefly about the Affordable Care Act, because it did create some different issues when it was passed in the special needs planning arena. Got rid of pre-existing conditions, which is the great part about it. Hopefully that will not change, but you never know. It does offer subsidized premiums for private health insurance, which are based on modified adjusted gross income. And this is important because the client does need some taxable income in order to qualify for tax subsidies. and structured settlements don't count. So there's some different ways that that issue can be dealt with trust, but you have to be aware of that. The ACA also expanded Medicaid, which does impact some special needs planning considerations. So when a case settles, one of the questions typically is, does it make sense to keep Medicaid SSI in place or forego it and go into the Affordable Care exchanges? And the impact that has in terms of the planning is that now trusts that are established for personal injury victims really should have language permitting payment for private health insurance premiums and distributing enough for that client to have enough taxable income to qualify for the subsidies. And in a lot of situations, it just makes more sense to have a trust in place that has special needs trust provisions and set-aside provisions, will distribute enough for the tax credits, gives that client financial management and protection from creditors and predators, but allows them the safety net of being able to access benefits that are available through Medicaid by having those provisions in it. So initially they might go into the exchanges and be in the exchanges for a while, but if they need Medicaid, the trust has the proper provisions that allow them to qualify down the line. And that's an important point, is future-proofing and trying to come up with different ways to make sure that that client is going to be protected ultimately. One point when we're talking about settlement trust, there is a very cost-effective tool that clients can use to create trust for themselves if they are not needing public assistance right away, which is a pooled settlement trust. Most of the time, these pooled settlement trusts will have provisions that I was talking about that allow a client to qualify down the line. But in the in the short term, these trusts have more flexibility because they don't have the restrictions that a special needs trust has. In situations where you've got a client who's incompetent, subject to a guardianship, this is going to provide the client more liquidity and flexibility over a guardianship, because in most instances, a guardianship is not going to be required on top of a trust with a corporate trustee. These are irrevocable trusts that are set up for health, welfare, maintenance, and support of the trust beneficiary. So basically, it can be set up for any type of need and can be used to pay for really anything. It basically is just a simple trust solution for both incompetent and competent adults who may need some type of financial management of their monies. And also, too, it can be paired with structured settlements. So for minors, there's a large benefit to that. And for really anybody else, it prevents them from selling their structured settlements to these factoring companies that prey upon people that have structured settlements, because by having payments irrevocably made to a trust, the client no longer controls what happens when the monies are paid into the trust. So by virtue of that, they can't sell the structured settlement in a factoring transaction. So that covers all the different planning issues that can arise from government assistance programs. What I want to transition into now is talking about some of the ethical and malpractice concerns for trial lawyers that can arise at settlement. And the starting point is really the laws that impact settlement. And some of this I've already talked about, so it'll be a bit of a refresher. But first is 42 U.S.C. 1396 PD4. Remember when I was talking about those special needs trusts that protect Medicaid and SSI eligibility? That is the basis for the law that exempts from being countable resources when they're placed into a properly created special needs trust. The next law is the Medicare Secondary Payer Act. We talked about that. Next is 104A2 of the Internal Revenue Code. 104A2 is important because it excludes from gross income personal physical injury recoveries and gives clients two different options. One is to receive a lump sum. If they take a lump sum and they invest it themselves, the gains are taxable and can impact their public assistance eligibility. The second option is periodic payments versus via an annuity, which is commonly referred to as structured settlements. With that, the client is not taxed on the investment gains. It can avoid disqualification from public assistance if used in conjunction with a special needs trust. And then constructive receipt, which is a tax doctrine, and you can trigger it by accepting money into your trust account. And I'm going to talk about that in a little bit when I talk about some of the malpractice concerns. So the reason I go over those laws is because the question is, do you have an obligation as a trial lawyer to advise the client about public assistance preservation and its impact, the impact of a settlement on public benefits and the techniques to protect eligibility? And then do you have to advise the client about financial options at settlement? I believe the answers to all those questions are a resounding yes, and I'll explain why. So commonly, trial lawyers focus on the dollar value of the case, which is their job, and that's exactly what your job is, to get the most amount of money and the best financial recovery for the client. But when the case actually resolves, there has to be a focus on the form of the settlement, not just the substance, because if planning is not done, that can lead to mismanagement of the recovery and loss of public benefits. And as a lawyer, the model rules require you to explain matters to the client sufficiently that they can make informed decisions and consult with the client. And you're allowed to talk about economic and social factors, and you've got to make sure that the client's interests are not adversely affected by the passage of time. So that leads me to the Grillo case. And this case has been often cited by people in our industry, but I do think it's important because in that case, these are all the types of allegations that form the basis for a legal malpractice action. So the underlying case was a med mal case for a birth injury. The legal malpractice claim was based upon a failure to set up a special needs trust. Constructive receipt was triggered by the lawyers taking receipt of the settlement monies and failing to set up a structured settlement. Instead, the planning that was done was completely inadequate, and the child lost public assistance and lost the opportunity to receive a tax-free structured settlement. So it's really difficult to defend the allegations in that particular case. The lawyers were, I think, pretty clearly negligent and guilty of legal malpractice. The case settled for $1.6 million against the plaintiff attorney, $2.5 million against the guardian ad litem. So be careful if you're acting as the guardian ad litem in cases. You want to make sure the proper planning is done. And if you look at legal malpractice claims overall, PI lawyers make up the largest percentage of malpractice claims, and advice about settlement negotiations made up over 23% of claims overall. So if you put those two categories together, that's the highest claim by type of an activity in that study. So this is an area where there clearly is a lot of liability. And frankly, there can be a lot of damages if the client is not properly protected. If they've lost public assistance eligibility, that's quantifiable. That can be a big number. If they've lost the ability to protect the settlement proceeds, because states have different protection statutes of annuities, as an example. They've lost a tax break if they were not told about structured settlements. Those are all quantifiable damages. So the question to, what does all of that mean? Well, here's my take, and you can take it for what it's worth. I do think that this is the right answer, is that clients have to have the laws that impact settlement explained to them, whether you do it or you hire experts like me and my company to do it. If you don't, there is no way that the client can make an informed decision, and they're going to lose the opportunity to exercise different options available under the law, which consequently brings about damages. And I think if you read that Grillo case and the commentary that's followed it since the years have gone by, really you've got to make sure you're consulting with competent experts in tax, trust, structured settlements to properly advise clients. Because if you as a lawyer do not address these issues, who will, since they're legal issues that impact the settlement of their case? And I'm often asked about threshold. Well, I've got a small settlement. Do I really need to do anything? Well, remember I talked about the fact that SSI and Medicaid beneficiaries, if they get more than $2,000 and they're single, they've lost their eligibility. So it's a very low threshold that's going to trigger this if they are disabled. So just be aware of it. make sure you're doing what you need to do in your practices to protect yourself. So in terms of settlement malpractice issues, I've talked all about public benefit preservation and that being a very fertile ground, but also structured settlements, which are done pretty routinely in catastrophic settlements, can present malpractice traps for the attorney. And this is where it really becomes imperative to have a firm that you work with that does structured settlement planning, that are experts that understand all these different issues. So one of the biggest issues that arises in personal injury settlements is constructive receipt, where a trial lawyer takes receipt of the settlement proceeds, thereby foreclosing the ability to enter into a structured settlement. Basically, constructive receipt means that even though the client may not have actual possession, if that money flows into your trust account, it triggers constructive receipt, which means that they no longer have the ability to do a structured settlement. So there's only two ways to avoid triggering constructive receipt. Is one, the defendant can fund a structured settlement with the company selected by the plaintiff, and the case can be co-brokered with a company like ours and the defendant's structure people, or you can set up a qualified settlement fund, which I'm going to talk about here in a few minutes, and the monies can be paid into that temporary trust to avoid triggering constructive receipt. When it comes to structured settlements, you should be aware of a couple of things to make sure the client is protected and reduce the default risk. One is that it can be set up as secured creditor. What this does is makes the client a secured creditor in the event that the life insurance company became insolvent, even though that's a very, very remote risk. If you do this, there's no cost of doing it. The client only stands behind the government in line when it comes to an insolvency. So you want to do this just as a matter of course. And we do that as part of our policy is always request secured creditor status, but oftentimes it's overlooked. Most of the life insurance companies offer a guarantee. So the annuity issuer guarantees payment by the assignee or the assignment corporation. So for structured settlements, you've got a shell corporation that actually is the one that's obligated to make the payments, and that's because of some archaic rules in the tax code. But just be aware of that you always want to make sure that there is that guarantee in place. And then lastly, in part of the planning, you want to make sure that there's diversification. So, for example, you could take a $3 million settlement and split it up into 5 different life insurance company structured settlements. So as an example, on a case that we handled, there was a $3 million net settlement to the client, minor child, parents were worried about default risk. So there were 2 structured settlements of $750 set up with both double A+ companies, and then 3 at $500,000 each to A+ companies. So there are ways to spread out the default risk by diversifying. But you also have to understand the different rating services and what they mean. So there's 3 different primary rating services: A and Best, which is the most frequently one that's looked at. The top rating is A++, but then there's also S&Ps, which the top rating is AAA, and Moody's, which is A, large A, double small a, are the top ratings. So you've got to understand those and know those. That's where a company like ours comes in to make sure that the client is protected ultimately. And in terms of pricing, you always need to know 2 different things: what the rated ages are and the annuity rates, because rated ages, the reduction of life expectancy drastically impacts the pricing of lifetime benefits. So the way that you figure out the best possible rates is by combining the rated ages with the annuity rates to look at what's going to be the best benefit provider to the client. And annuity rates vary pretty dramatically amongst the different companies based on how aggressively those companies are going after business. And all the life insurance companies typically offer daily rates, which are sometimes better than the book rates on settlements of $250,000 or more. One thing that you should be aware of is that rated ages can make a drastic difference in terms of how much benefits the clients get for the same settlement amount. So this example is a minor child with a hypoxic brain injury. One life company gave a rated age of 64, settlement amount was $2 million net to the child. Under the this particular life insurance company, the client would get $13,697 per month. So the next highest rated age was a 51, and in this case, the defendant's structured settlement broker was offering the 51 because he was not a provider of the company that issued the rated age 64. So had Synergy not been involved in this case, the client would have gotten, the minor child would have gotten over $2,000 less per month, and over the guaranteed payment time frame, it would have translated into $500,000 less and $2.4 million over life expectancy. That's a pretty drastic difference. And just for illustration purposes, even a smaller settlement, you can have a pretty drastic cost differential. So you can see in this chart that the lowest cost was $202,000, the highest cost was $228,000. It's a pretty significant differential. One of the things that comes up sometimes is estate tax concerns, because when somebody dies with a structured settlement, the present value of the remaining guaranteed payments are includable in their estate. So if you have a premature death and a large guarantee, it could cause an estate problem, although these days the estate taxes has gone up, so the amount that's excludable has gone up so much that it's usually not too much of a concern. But there is sometimes a need for liquidity when someone dies, and that can be because there's other desirable investment options post-death, or there's an estate payback from Medicaid, or it could be a Medicare set-aside. The funding parameters are just not necessary post-death. So there is an estate planning commutation rider that can be added at no cost that provides a lump sum at death to free up cash and create liquidity. But that's got to be done at the time of settlement. So you've got to make sure that these types of issues are addressed. And really the only way to do that is by employing experts such as our company that can guide you through these issues. So the last thing, and I've covered a lot of material, I wanted to talk about qualified settlement funds, because typically there is a crunch at settlement because you want to get the settlement dollars into your trust account. So sometimes it makes sense to create a QSF, which gives you time to do the planning, but allows for immediate settlement and basically a cash settlement with the defendant, so you can get paid quickly, but you can avoid triggering constructive receipt. These are trusts that are created pursuant to Treasury regulations. They're a short-term holding tank. As I said, it allows for what looks like and feels like a cash settlement. They're used all the time in mass torts, but they can also be used in single plaintiff cases involving one or more claims. It gives the client time to plan because the funds are immediately obtained from the defendant. The temporary trust is funded, so you don't have to worry about, say, if there's the potential insolvency of a defendant, you want to get the money quickly, but then the money is just sitting in the QSF while decisions about planning can be made about whether there should be a structured settlement, a special needs trust, a Medicare set-aside. It does require court approval and some additional costs, but in many instances, it just makes sense. There's only 3 requirements to establish one of these. It just has to be established pursuant to an order of a court of law, and it has to be established to resolve or satisfy one or more claims arising out of a tort. And then the fund account of trust is a trust under applicable state law. So the way it works is basically you settle with the defendant just like any other cash settlement, execute a standard cash release. The settlement check, instead of being made payable to your law firm's trust account, is made payable to the qualified settlement fund. You petition the court and obtain an order creating the qualified settlement fund. The funds remain in the QSF without violating constructive receipt until all the allocation decisions are made. If you've got multiple plaintiffs, liens are satisfied, special needs trust or MSA is created, and the amount to be structured and the plan is decided upon, including attorney fee structures for deferral of contingent fees. But When the funds are deposited into the QSF, legal fees, your fees can be paid immediately if they're not going to be structured. So it allows for that immediate payment while the time is necessary to plan for the client is there. And then once the funds have been all distributed, then the QSF terminates. So why and when would you implement a QSF? If there are multiple claimants and allocation issues between, that is a classic case for application of a qualified settlement fund. If you have multiple layers of coverage and you want to aggregate settlement monies, that's a great reason to establish a QSF. If there's difficult lien resolution issues that are going to take some time and you don't want to have funds sitting in your trust account, they can go into a QSF. If there's public benefit planning issues, if there's structured settlements, whether it's the client or for your fees, all those issues or all of the above are great for using a QSF. So I covered a lot of material in just a little over an hour. I wanted to tell you real quickly about Synergy. Synergy allows trial lawyers to focus on what they do best by handling the difficult issues of settlement, like lien resolution, Medicare secondary payer compliance, settlement consulting and government benefit preservation, structured settlements, trust services, and tax deferral of fees. So all the things I talked about today are things that we're experts in and we handle day in, day out for trial lawyers. If you have any questions about today's presentation, there's my email address and our phone number. Always happy to consult with you. We don't charge any initial consulting fees, so feel free to take advantage of the offer to help you when you have these complex cases. And thank you for spending a little bit of time with us today. We'll open it up for questions here in a moment.